All right, thank you very much. And let me also extend my greetings to my co-panelists. I've followed the discussions. And let me first indicate that there are no gaps relative to how judgments are to be executed, whether constitutional judgments, whether private judgments, etc., etc. And I'm surprised that they have to take the Supreme Court to halt the process. If as a people, we are all committed to follow the laws that we have passed, I think this matter is as easy as ABC, and I insist, as easy as ABC.
Explain to us.
The High Court in Tamale delivered a judgment. Per CI 19, there is a 7-day automatic stay. So from the time of the judgment, for the first 7 days, which Speaker Babin said, nobody could take any step to execute the judgment. The registrar at the High Court in Tamale didn't have the authority by then to serve any process seeking to execute the judgment. That's the first point. Now, after the 7 days, that's where the issues come up. Is there a stay or no stay? After the 7 days, there was a motion for stay of execution. And what's the effect of that application? The effect of it is governed by CI 19, Rule 27, as amended. Now, if we take CI 19, Rule 27(2), it says expressly that when such applications are pending, execution of the judgment is stayed. Rule 27(2) of CI 19. This has also been given a judicial blessing by the Supreme Court in the ex parte Millicom Ghana case. I think it was reported in 2009, 2010, Supreme Court of Ghana law report. Now, in that case, the Supreme Court said the moment an application for stay of execution is filed, it stays execution under Rule 27(2). And so, I'm going back to Tamale. The lawlessness, the illegalities, I will trace it down to the registrar at the High Court in Tamale. At the time that, presumably, I presume that he served the Speaker of Parliament or the Clerk of Parliament that there was a vacancy. At the time that that warrant was served, there was pending on that particular docket a motion for stay of execution. Question: so on what basis was the clerk notified that there was a vacancy? That's the first point. Now, if you come to Parliament, I also listened to the arguments on the floor, the majority leader and the rest. I think some members of Parliament, especially my learned colleague, the majority leader, misread CI 132. But there's an argument that CI 132 has amended CI 19, and by virtue of that, if you file an application for stay, it does not stay. If you take CI 132, it does two things to Rule 27 of CI 19. It amends Sub-Rule 1 and Sub-Rule 3. Sub-Rule 2 was not amended. And Sub-Rule 2 is a provision that deals with the situation where when application is pending, application for stay is pending, it stays execution of that judgment. So as simple as that. And so the moment the registrar at the court below served the Speaker of Parliament, and also having been notified, Parliament having been notified there was a pending stay of execution, the Clerk of Parliament, with all due respect, also had no authority to have notified EC about the vacancy. That's why I said it's as simple as ABC. Again, EC, as you all agree, is also a party in this particular matter. In fact, the court below was the second respondent. And they were also served with every process, the stay of execution. When they also got that process, they should have also indicated to the Clerk of Parliament that we've been served with this. But there is a pending application for stay of execution that also stays execution. Let's remember that what was done at the Tamale High Court relative to the service of the warrant or order on the Speaker can also be brought up at the Supreme Court for it to be quashed on grounds of illegality and nullity. And so if EC didn't do it, and the issue was raised on the floor of Parliament, I expected that the Honorable Speaker of Parliament will have delivered a second ruling on the matter, because the time that he delivered the first ruling, he relied on the law, specifically the 7 days automatic stay. The second argument that came at the time, there was a pending stay of execution. And if the Speaker had taken a look at that application and then the law, it will have given the ruling to the effect that the Clerk of Parliament erred by forwarding that notification to the EC.
I've heard you give the education around this subject, but there are those who say what you are saying does not help because of what is said to be the mischief rule. People will do mischief by simply filing applications to stay processes when they know that they don't have a case, and then that will stop the functioning of the affairs of state. What do you say?
There is no mischief here, with all due respect. There is no mischief. Now I'm going to cite two instances. If there is a judgment between Samson and then myself, with respect of a house, you win the case at the High Court, I'm in possession of the house, you want to demolish that house, I go to court to file an appeal and stay of execution. And that house is demolished despite the pendency of that application. If we didn't have Rule 27.2, commonsensically, what happens to the application pending? If you go to the court, because that particular court has been used to execute the judgment despite the pendency of that application. So in terms of common sense, that application will have to operate as a stay of execution. Now, let me come to your point. Constitutional matters, statutory matters. We are now talking about judgments. The Tamale one is a judgment. It's not an interlocutory application or process. Now, when it comes to final judgments, there's no distinction between constitutional, statutory, or private judgments. They are all judgments. And their execution is done in accordance with CI 19. And so, whether constitutional or not constitutional, it is a judgment.
Okay.
Usually, we want to look at it this way. Oh, there may be a mischief because the person will file an application. That application will stay execution. That is fair. Parliament has passed that CI. If we want to look at instances where there are some situations that we think that stay should not operate as automatic stay, Parliament can look at the law again and say, when it comes to ABC, we are not going to countenance application for stay as stay of execution.
So you have been making the distinction between stay of execution and injunction, and your view is that people are reading the injunction processes into stay of execution because the injunction would normally have come when there is no judgment, but the stay would have come when there is a judgment. And you say that makes a difference. Is that your point?
Exactly, Samson. I've also heard the argument that by virtue of the Supreme Court decision in the total removal case, by virtue of that decision, it means that if you also file stay of execution, it should not stay. Now, if you look at the Ekwesifwa case relative to that subject, it is about injunctions. Injunctions pending proceedings, interlocutory injunctions, not injunctions granted after judgment. The Supreme Court realized that as practitioners, for a very long time, there is ex parte Moffat, and then IET and the rest, which have given the decision to the effect that when a motion for injunction is pending, you cannot go ahead to do the very thing that you are seeking to stop you from doing. That has been the position of lawyers, that is, we use that word to cite contempt of parties. You can realize that no, when it comes to injunction, when it comes to constitutional functions or statutory functions, that aspect of ex parte moffat should not work. And that's why, in a very clever way, which I endorse, the Supreme Court said, when it comes to constitutional functions, the filing of application for injunctions does not operate as injunctions unless an express order is decreed.
Okay.
Simple as that. That pronouncement of the Supreme Court does not extend to stay of execution.
Okay, thank you. Dr. Pumpini Asante has a question for you, but all of us lawyers, we have often said ex parte moffat, and even when we make the corrections, we still don't come to the fact that it is not ex parte moffat, it's Republic versus Moffat, ex parte alote. Okay.